people. Here we go. Some news headlines. Let's go. Okay, so as I said, when the judge hears things that are credible or that he has concerns about, he'll usually bring parties together, including if he heard things about the jury. Well, now they're back in trial to talk about something. I'm assuming this is video information, but let's see.
Correct. They also talk about exaggerating some aspect of the evidence. The defense, the state, I should say, is totally correct that the incident on 75th Street that happened more recently, what was the name of it? Flint. I admitted that because I said, no, that those rules don't apply because this is actually an image. These are images of the event occurring as opposed to a statement of the accused or a statement of a witness, which were the case in the Franklin and Anderson cases. And so I do feel that those rules are not, the rules to be derived from Anderson are not strictly applicable to the to footage from the actual event which is claimed to have been criminal. So it's not just that one case, there have been other cases that I've admitted these videos and let the jury play them. I complain about the case of, well, I don't remember the man's name, but he was convicted of attempted murder of a police officer. Well, actually, I think of reckless endangerment or something, but
Now, some people are cracking on this judge that he's kind of crazy and he doesn't know. He's just verbalizing his thoughts. I mean, we all kind of go, I mean, when I make videos, sometimes people say, man, you tell us all that, just get to the meat. Well, I mean, he's just kind of verbalizing where he's coming from, kind of probably to cover his butt. I don't know if he does that all the time, but I don't have a I don't think he's stupid because he kind of goes off on these different things, because he's verbalizing how his mind is getting to where he's at and what he remembers and why he's making his ruling the way he is.
Because of video footage that they had to come down here and watch on a tiny computer, and we had to bring them down 3 at a time because we could only let them see it one time. I think that's so outrageous. But, you know, I have to be aware. You want me to kind of just let them have what they gather, what you say, although actually most of the time your office has come in here and told me, no, Judge, don't risk our case. So don't send this. What do you want me to do? What do you want me to do? Tell me.
Judge, I do not believe Anderson applies directly. I believe that because it is of all these requests are of the incidents themselves, that I believe the jury should be able to watch them as they see fit, watch them, pausing them, rewatching them, watching them in any.
Now, the reason why the prosecution, the DA, wants the jury to be able to watch all these videos is they think it's going to clear it up and that they're confused. And if they watch the video more and more and they see the shooting, the odds are they'll rule with them. So that's why he's arguing, oh, yeah, I think they absolutely should be able to watch it. You remember early in the trial, there was talk about sometimes they didn't call it this. I'm just calling it this, like video saturation, to where you watch a video so many times and so often that it loses its value and you just kind of fill in the blanks, or you already know what it's going to do. So you don't want to watch it with that, you know, specificity, so to speak, that you would if you were really looking for something, because you've seen it so many times. But we'll see.
Way they see fit, in any configuration they see fit. I believe that the Franklin and Anderson cases, I understand how someone's statement, a videotaped statement, could be overemphasized. I do not see how videotapes of an incident could be overemphasized or looked at too much. And really that's what this whole trial has been. While there's been lots of testimony, almost everything testified to is on video. So to me, I believe it is clear that given that
most everything testified is on video, I don't think the video of the weasel, the penguin, whatever, I don't think there's video of him trying to intimidate a witness where he's showing him a picture. I guarantee you they didn't videotape that. I guarantee you he didn't do a report on what he did in that room. He'll argue now that that's not what happened, but he didn't do a report when, as he likes to say, isn't it true that it was more fresh in your recollection when it happened? That's why you do reports, dipshit.
As a videotape of the incident, they should be able to view it as they see fit. Now, Anderson, again, of a statement, says it should be in open court. That certainly can be done. The jury may feel uncomfortable, obviously. So I think if the court makes specific findings as to why it's appropriate in this case to send it back, we could send it, or actually what I would propose is making the courtroom the jury room, clearing out the courtroom, checking for any devices that would be recording the deliberations. We can either give them all the exhibits and instruct them to only watch the numbers that we agree on or that are allowed, or we can put them.
Have the courtroom check for listening devices? Wow. we're really getting into some James Bond shit here. Bum ba dum bum 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 ba dum
on a separate drive the exhibits that they've requested or that they'll be allowed to see, and they can essentially have access to all the screens here, and they can play it and do it as they see fit. Now,
I still don't really know what they're arguing about. Are they looking for a drive? Or are they saying somebody secretly recorded something that the jury wants to see? But because it just started when it started. I played it when it started.
with this distinction of it being the incident itself, if the court makes findings of why it's appropriate, the state believes that it will survive any scrutiny on that issue if there is any kind of guilty verdict.
Well, you're suggesting an abandonment of the insulting precedent of the last hundreds of years that the jury might overemphasize some aspect of the exhibit. He says it should be played only once if it's played at all. And you say played as much as you want, which my intellect tells me is the best way, because as I talked about the Tsarnaev case, that's how it got solved. And it seems to me this is a pursuit of truth, and you should take the course that you think will lead you there. And if the jury thinks they want to look at it 80 times and they want to talk about it and criticize each other for their respective views of it, I think they should be allowed to do so without interference on our part.
Now, you just heard me say why the DA wanted them to look at it a lot. I agree with what the judge said. I don't think that's the reason the DA wants it. The DA does not want search for truth because the truth hurts them. They have been doing nothing but manipulating, lying, hiding, twisting, just making a joke out of the freaking evidence in front of the jury. So they are not looking for truth. I believe the judge means what he says, and I agree with him. If they want to watch it 50 times, let them watch it. They're the jury. You put it into evidence, let them see it. My problem is there's evidence that you didn't let them see. So you're going to let them watch evidence that you allowed, and they can watch it 80 times. However, the evidence that you didn't want them to see, like criminal history, prior violent acts, the stuff that you don't want them to know, they'll never get to see. To me, how is that fair and seeking the truth?
That has not been the law in this country, which, in my estimation, treats jurors very poorly. And so I don't know. Your office, this is the first for me that your office is agreeable to this. But that doesn't mean you can't do it, because you can.
And usually, the only time I've ever encountered this issue, I can't speak to everyone that's been in my office the last few years, the only time I've ever encountered this issue with you or any judge, I believe, is because it's a statement. And the video of the incident is different. So, and what...
Oh, so it sounds like the DA doesn't want them to see a statement that was recorded, but the video's okay. Now, why do you think that is? Because a video leaves room for interpretation, and a statement pretty much is clear what the guy said. Again, distorting and hiding the truth, not looking for justice or the truth. This DA's office is freaking pathetic.
What the court must weigh is whether the exhibit will aid the jury in proper consideration of the case, which you and I at least agree, whether a party will be unduly prejudiced by submission of the exhibit, they've already been submitted, and then improper use. I understand how, especially a statement of a child or a statement of a defendant being reviewed over and over and stopped and rewound, how that could be an issue. But if of an actual incident like this, which is what this whole trial has been, is showing videos of the incident. And I think it is fair to this jury and fair to the process and frankly fair to the defendant if they're able to see the videos as they see fit. So we can either give them, if the court adopts this, we can give them a drive with the acceptable exhibits. They can play them. They could have access to the court technology if everyone is kicked out. And it can continue as that. I don't know if the court can allow that with its calendar, but...
This is more important than anything I've got on the calendar.
The state's position is that Anderson is very strictly relevant only to a statement of a witness or defendant.
By the way, what about... I now have had the chance during the break to read the defendant's motion for dismissal.
Yes.
And there are allegations made there about the material that was provided to them.
Yes.
Certainly, if I follow through on what you wanted, I think I warned the other day because I was queasy, very queasy about this particular exhibit from the drone, and we exchanged a lot of emails over the weekend about it. And I think I warned you the other day that you're putting an awful lot of emphasis on this, and if it turns out that it's not technologically sound, I referred to it as the situation as a house of cards. This is just more weight on that. If I now allow them to review it without restriction as to the number of times,
Judge,
you comfortable with that?
we are. Now, if I can respond at least to that portion of the motion to dismiss, it's factually inaccurate. So let me go back to the first Friday of trial. Mr. Lukowski was testifying. In the middle of his testimony, I got a notification that there was someone at our office who was refusing to give his name with a drone video. This drone video was shown on Fox News a couple days after the incident. It apparently was on the internet briefly and then taken down. The defendant's first attorney, Mr. Pierce, appeared on the Tucker Carlson show and discussed the video and seemingly brought the video.
Ooh, I don't even think they can use it for that reason. That's basically like his attorney providing evidence against his client. I think that would be a suppression issue. If my attorney goes on Fox News and gives up shit that is used against me, I don't think that can be used against me. Maybe there's some attorney out there and cleared up comments. I think that's grounds for suppression of that video right there.
We've been told since then by the person.
Somebody's going to say, well, he's not his attorney now. It doesn't matter. When he was his attorney, the privilege existed, and he doesn't lose that privilege just because he's not his attorney now. The privilege lasts until the client dies.
The footage that they've sold the video to Fox News. Now, we've had a poor quality of this video the entire time. It's actually in Exhibit 41, which the defense submitted. On Friday, the individual who took the footage, who had been unable to find, came and airdropped the footage to Detective Howard. Airdropping is a way that it just goes from phone to phone. It doesn't go through text messages or email. It has to be iPhone to iPhone. So in the middle of Mr. Lukowski's testimony, I asked Mr. Howard to go, and our investigator, to go speak with this individual and see what he had. I suspected it was this video from the Tucker Carlson show. It was. Detective Howard got a airdrop copy. He brought.
Let's subpoena Tucker Carlson. Look, they can't subpoena anything now. This is why we're having this argument after the fact. This is kind of rare that this is brought up, but because of the motion for the mistrial and the dispute of the evidence the jury has, that's why the judge has kind of got to address it. Because I think once the jury gives a verdict, I don't think the judge can do a mistrial. He can overturn the verdict if it's guilty, but I don't think he can give a mistrial after the verdict. I may be wrong.
Brought it into court. As soon as the next break happened, which I believe was just minutes after he arrived, as soon as the next break occurred, which I believe was just minutes after Detective Howard arrived, I took all three defense attorneys in the back to discuss a couple of issues which are not relevant, and I also indicated that we now had a much better quality drone video. Detective Howard asked them how they would like to receive it. Ms. Wisco asked it to be emailed to her. He emailed her the file. Now, somewhere along the lines, whether it was, it appears the issue is, I believe Ms. Wisco could not have an airdrop because she has an Android phone. Going from an iPhone to an Android, it appears somehow compressed the file.
I have an Android phone too.
We did not know that this would occur. If I knew how to compress files and knew all this technology things, I'd have a much better job. So this file was given to us. We gave what we fully believe was the full file to Ms. Wisco.
Okay, so in my other video, I talked about it's one thing for them to give a file or a compression, or if they intentionally compressed it or intentionally did it. If this is what they're saying is true, and they can put the detective on the stand and ask him under oath, they won't put the attorneys on the stand and ask them under oath because they're protected. They're special. But if they put the guy on the stand and says, hey, she says she wanted to email, I attached a full email. And somewhere between my email and their email, the email process compressed it, and that's why she got a weak copy. That is not the prosecution's fault. As much as I want to take up and call these guys out for being crooked, that would not be a DA or prosecution issue. However, if the defense got it and immediately said, hey, it compressed it, we want the full copy, then they could have done that. So right now, I'm leading that the DA didn't intentionally try to hide this better video.
It was admitted to evidence. It was the authenticity was stipulated to. It came in without objection. We've heard many times this trial how there was no objection. It was an exhibit for 4 days. And
okay, so let me interrupt on what he's talking about, stipulation. Stipulation is where both sides agree that the facts that they're talking about is correct. Neither one wants to challenge. It's basically admitting something without objection, without challenge, and they both agree that it's true. Like, Your Honor, I would submit for, and this is like judicial, I forgot the term now that I'm talking about. But if one of the attorneys goes, it was 10 o'clock when this happened. Would you stipulate to that the time was 10? They go, yes. That means they both agree it was 10 o'clock. There's no argument about the time. So he's trying to say because they issued the exhibit and there was no argument, that makes it legit. That's not true because they didn't know that the thing had changed and been compressed. Otherwise, they would have objected. Now you get into should they have known, could they have known, and whose fault is it that they didn't know? So that's kind of the issues on why I'm siding with the DA on this, which I really hate to do because they're such weasels. But I actually think this time they might be right.
Played and shown to the jury and on the screen for 4 days. And then on Friday is when I think we all discovered that something had happened to Ms. Wisco's file. She played it on the big screen. It clearly looked different than the copy we all had. I believe we offered to airdrop it to the other attorneys, and I think it was declined because they didn't know how to use airdrop. And then we got her the full copy. We cannot be held responsible for the software on Ms. Wisco's phone. We didn't compress anything. We didn't change anything. That would have been something that happened in the transfer that we had no knowledge of. We of course did not mean to give them a different copy. And until Friday, when Ms. Wisco played it and it looked different than what we've been looking at, we had no idea it was any different. And then when requested, I gave her. So what I did is I took an email from Detective Howard. He emailed me the file.
Email is a very bad way to do evidence. First of all, it's not secure. Second of all, it could be corrupted along the way. When we gave evidence, it was on a disk. And we made a copy of the disk. We reviewed it. We confirmed that it was accurate. And then we gave it to you. And that's how it should be done. So, I mean, if the defense has a good argument, they should say, wait a minute, Your Honor. If they're giving us evidence, they ought to know that it can be changed in email. And you know what? My guess is none of these attorneys will freaking accept a damn file through an email again. You either give me a hard copy or you give it to me on a freaking disk.
It was not compressed.
Maybe they use thumb drives instead of disk now, but disk was always like a good hard way. Thumb drives can be erased, magnetic, it's electronic, things can go wrong. A disk is usually, I would rather have something on a disk than on a thumb drive, personally, as far as secure-wise.
I don't know, probably because it's Apple to Apple, or I was using Gmail at the time. It was the full, as far as we know, the only copy of the video we were ever given, the only copy that's ever been had, and then I put it on a thumb drive to give to the State Crime Lab. So I cannot explain why Ms. Wisco's file had been compressed. That is not something that we can be held accountable for. We didn't know it. We don't, and if Ms. Wisco knew it, it wasn't brought up until Friday. Now, there was some dispute Friday about there being different copies. There was no different copy. The software on Ms. Wisco's phone, or whatever software she used to view it, compressed the file. The only compressed file is the one Ms. Wisco has. All the ones that we have seen, and we did not alter the file. None of us know how to alter the file. None of us know how to compress the file. We wouldn't have had time to do so. You can probably go back on the footage and see when Mr. Howard, Detective Howard brings it in, and while Mr. Lukowski is being questioned, we're looking at it to see if it's the drone footage that apparently the defendant's first attorney had or was aware of. And I understand he's different attorneys now, but this is still the defendant's attorney at the time knew of this 3 days after the incident and was talking about it on national television. So to somehow now accuse us of compressing a file and somehow being able to do this technical wizardry to somehow...
Just because it's technical wizardry to you doesn't mean it's something that's really far out of the fetch. I mean, 2 + 2 is 4 is technical wizardry to a freaking kindergarten. So just because you call it names and you appear that, you don't have any knowledge of it, that just makes you stupid on the subject.
Sabotage the defense is preposterous. The defense saw this video and thought highly enough of it that they went and bought a large television that is now being used in court because they wanted to show it. And now all of a sudden to come back and say, well,
Wow, the defense had to buy the large video for court? Wow.
Had a bad copy. They could have checked. They could have asked for a thumb drive. They could have asked for whatever. As far as we knew until we had this hearing on Friday, everyone had the exact same copy. And that Ms. Wisco's phone compressed it is not our problem. It's not, we're not responsible for that.
Didn't go to her phone.
Well, no, one at a time. One at a time. Well, why don't you start, Ms. Wisco?
Are you talking to me? Yes. On November 5th, 2021, I received at 10:33 a.m. an email from Detective Martin Howard with one video file attached. It was a 4 millibyte video.
Did she just say millibyte? What the hell's a millibyte? Is that like part of a freaking donut? A millibyte? What?
On November 5th, 2021, I received at 10:33 a.m. an email from Detective Martin Howard with one video file attached. It was a 4 millibyte video.
Okay, maybe I'm laughing because I'm stupid and somebody's come here. Dude, a millibyte, everybody knows about. I don't know what a millibyte is. I'm thinking she's talking about a megabyte. Nobody's correcting her because she's an attorney and she's female. If you correct her, you'll be sexist. Or, you know, it's okay to be stupid now and nobody can correct you. Maybe she's right and I'm the stupid one. We'll see.
That was titled IMG_0159.MOV. I have never looked at that video on my cell phone. As soon as I received that video via email, I downloaded it to this laptop, which is the evidentiary laptop we've been using for the duration of this trial.
Yeah, but that doesn't matter. She whether it was compressed or not, just because she downloaded it from her phone, the compression had already taken place when you send it. You shouldn't have got a freaking good piece of evidence through an email. I mean, that's just not smart a move in my book.
This is a Lenovo. And I relabeled it after it had been brought into evidence by the state as Exhibit 73 because it was Exhibit 73 for ease for bringing it up, showing it to the jury. After we found out in Friday that there was this discrepancy after the
A millibyte. Is that like a bacon-a-bite on a bacon BLT sandwich? Yeah, I need a bacon-a-bite on that.
videos being shown. And for the record, we did not buy that TV because of this drone video. We actually brought it in for John Black's slowed down testimony. That was the reason we brought this TV in. However, when we were in court, I played the Exhibit 73 on my computer because the state's computer wasn't here. ADA Kraus was the one who brought up the fact this isn't the good quality video. We didn't realize until playing them side by side, mine and then the state's, that there was any difference in quality. That was Friday. After Friday happened, I emailed both Binger and ADA Kraus, and I asked for an exact forensic copy of what they had given to the state crime lab. ADA Kraus responded back to me, forwarded me the email he's talking about to Detective Howard, and that also contained one file named as IMG_0159.MOV that was a 4 megabyte file.
Oh, she corrected it. She was wrong. Man, I was getting nervous. I was like, man, if she ends up being right, I want to look like an idiot. I've never heard of a millibyte. I guarantee you, the other DA ain't got no such thing as a millibyte when it comes to a donut. You can take that shit to the bank.
Simultaneously, ADA Binger had been in contact with me, told me I could come pick up the file from a flash drive. I drove here, I had him take me inside, and I confirmed that this file that he said was directly provided to the state crime lab was an 11 megabyte file, not 4. So the information contained in the flash drive was over double the size, almost 3 times the size as to what was emailed to me. When ADA Kraus followed up to me with that email, forwarding me his email from Detective Howard, it was the same 4 megabyte file that I had gotten previously.
So clearly, Attorney Wiscon's email is compressing these files. That's not our responsibility. I didn't write Outlook software.
You know what,
I forwarded. I forwarded.
But wait a minute, I don't know if she had finished.
Every other piece of evidence from the state crime lab in this situation has been provided to us via Dropbox. Dropbox provides an exact forensic copy of what they have. The file title name in this situation should have been exactly the same as the one provided to the state if it was the exact same copy. The file name was nowhere near similar.
Oh, now we got a good point. If the file name was changed, that means somebody did something to the video before it was sent. So she's got a good point here. Maybe the little crooked DA, their little house of cards is falling on them.
That was provided to the state's crime lab that Attorney Binger gave me a copy of on Saturday had a very long, convoluted title that involves lots of letters and numbers that are the type that are usually associated with files taken from a drone because they indicate a lot of different information like the location of the drone and the time. The file I received originally on Friday the 5th was not labeled that same and was not the same file amount. There's no way that what ADA Kraus is saying is true because the file name was...
Okay, so there's 2 things here. The file name's a good thing, but here's an easy way to test this theory. Where's the file? Give me the 11-byte file. Detective, I want you to email it to her right now. Put that 11 megabyte file, attach it, and email it to her. Now I want you to open it, and I want to see whether it's large or small. And that will solve this 2 seconds flat. What? I gotta go there and be freaking the detective of this courtroom? Nobody got 2 brain cells to rub together to figure that out? Second of all, I still haven't heard how this hurt their case. If the newer, bigger file does not have something that helps their case or that they couldn't see in a smaller file and now they could have used that to help their case, then there's no harm, there's no foul. They didn't get the right stuff, but it didn't harm their case. You need to show damages on why this file was compressed and how it hurt your case, and I haven't heard that yet.
Not have changed if my computer was compressing anything. It was a different file that we were provided from what was provided to the state, at least for what Attorney Binger gave me on Saturday. They're completely different.
I think we're confusing the issue here. The work product of the State Crime Lab is sent via Dropbox. That's how they've submitted all the videos that they worked on and the photos they worked on. The email from my personal Gmail account is the file that went to the State Crime Lab. I was told to bring it to the State Crime Lab. I was already home on Saturday. I did not have access to anything but my computer. I had Detective Howard email it to me, and I put it on a thumb drive at home, and I took it to the crime lab. I don't know if Mr. Binger...
Why didn't you email it? If you emailed it to the defense, why didn't you email it to the crime lab? I'm waiting for the donut defense. And I was eating a donut, and somehow I dropped it, and it hit the send key and the compression key on the keyboard, and it compressed and sent the file, and it's the donut's fault. I can call Krispy Kreme in, and you can have them testify as to, what their donut did.
Somehow retitled it, but the image I gave the crime lab is on my phone as the title that she indicated. That was the one that went to the crime lab. And I will testify as an officer of the court. I take offense that what I'm saying is untrue. Clearly...
Well, obviously we're going to have to take this testimony under oath, and we're going to have to get somebody to explain all this.
Yeah, that's my boy. That's what I'm talking about. Get somebody under oath, and let's have somebody either lie or fess up. Good. See, most judges don't do that. They'll just say, well, all right, we'd have that. All right, can we move on? Did it hurt your case? Well, how did it hurt it? Do you want me to give them an instruction? Okay, you want to tell them? What do you want to do? You want to instruct them now? I mean, there's a bunch of ways to handle this, but for him to say, we're going to take testimony under oath, oh, shit. Both those freaking crooked-ass DAs' little nuts just shrunk up to the size of a chickpea, and they're like, oh, shit, I don't want to get on the stand.
Who has some competence, which...
If you look at the report from the State Crime Lab, they indicate the originating file that they received was the one with the expanded title that we did not receive until Saturday. If it had been the same file as ADA Kraus says it is, why wasn't that labeled on their receipt as being IMG 059?
That is a great question and a great point, and somebody under oath ought to have to answer it.
159.
Mr.
If
Kraus?
that's the exact same thing, then that does not add up.
Mr. Kraus?
Why did he include in his report a different title?
I'm looking at the email. It is image0159.mov. When it's downloaded to a computer, perhaps it has a different title. On my phone and on my Gmail, that is the image. I'm watching the video right now. This is the precise one that was given to the State Crime Lab. I had no other access. At this point, the first time this was ever put on any kind of hard drive is when I did it Saturday at my home. And I'll do a little experiment here. I'll save it to my computer and see if the title changes. But
Oh my, are you serious? Is he really trying to argue that it changes the title of your freaking thing you're sending? I know of no program that changes the title of something. None. That's crazy. You don't attach something and it changes it. Oh, I'm attaching a file named Donut and it changed it to BLT. Really?
I'm going to do this. Pardon me?
I accidentally saved it 3 times because I was trying to re-download it multiple times, and it all saved it as IMG 0159.
Okay, well, you know what? We can't resolve this now because this is going to require expert.
IMG is normally how files are saved on an iPhone. When I copy a file on my iPhone, all iPhone files start with image IMG and then the last designation .mov or .jpg or .png or whatever. But they all start out with IMG. I hate it about Apple. I cannot rename a file on my Apple phone. So maybe he downloaded it to, but even if he I don't know if I've downloaded a movie to my iPhone. If I take a movie, it labels it. I don't know if I've downloaded one.
Testimony from people, and we're going to have to take testimony under oath. This is what the facts are, and so that I'll reiterate my comment, which started this discussion, which was that given the cloudy picture about this particular exhibit, this is a high-risk strategy for the state. I was queasy about this from the beginning.
High-risk strategy means they're freaking being sleazy, and they're trying to bend the rules as much as they can bend them without breaking them, and it's easy to step over the line. If they had a good case and they were ethical, they wouldn't need to take high-risk shit like this. That's what that means.
and I'm only quizzier about it now.
Show the jury the exhibits. I'm really not concerned about the image. As I've said multiple times, I believe much too much has been made of this image. Mr. Baird even mentioned it in his closing. We didn't.
Much too much has been made. He said in his closing, or he sold the defense when he was arguing, that this exhibit is like the sixth most important thing on his list. And now much too much has been made about it. If it's not much too much, why not just get rid of it? Oh, no. We can't do that. Lying, unethical DAs.
Show it in either our closing or rebuttal. The other evidence was admitted without objection with a stipulation to authenticity, and I believe it should be played. It's already been played for the jury, and they should be brought down, and we can put all the other exhibits on a thumb drive outside of 160, what is it? Outside of exhibit 155, which is the image that the court has received over objection. But the other exhibits were not objected to. And again, the defense, although a prior attorney, had access to this video 3 days after the incident. So to now claim that they're somehow prejudiced is preposterous. I understand it's previous counsel.
I don't know why they're letting her talk about millibytes when they should be arguing. But anyway.
But it's still the defendant's attorney. He was charged with this crime. And if Attorney Pierce did not turn something over that he had and that he seemingly brought to the Tucker Carlson show, that also is not our responsibility.
Your Honor, can I briefly respond to that?
Yes, sir.
Mr. Pierce was my client's attorney. As Mr. Kraus said, Tucker Carlson purchased that video. That video is very different from the video that was delivered here in quality, color, there. We stipulated to the video based upon what they gave us. We didn't see it as anything different. We were given...
I want to stop you now.
Okay.
Because why do you say that the one that Mr. Carlson bought, Tucker Carlson bought, is different from...
Black and white.
Ah, that was, okay. Go ahead.
And we stipulated to that video when we looked at our copy because it didn't add anything except color. We didn't have the quality. And that's where this whole problem starts. And we weren't aware of the quality until after the evidence had closed on Friday, when we were here and it was plugged in as Ms. Wisco was saying. That's when we found out there was a problem, what had been given to us versus what they had. That's when the whole problem comes up. So that's as to that video. The other one, and I'll just say it because it's going to be an issue, FBI aerial with all POI'd marked. That, when we're going over this list, it's come to my attention. I played that for the jury. It never got marked or moved in, even though it's been played.
Are you kidding me?
I am not kidding
Can
you.
we put it in evidence now?
That's what I think would be the proper way to do it.
If the defense agrees that all the drone videos go back, we will agree that should
Can
be
I
marked
run a
in
compromise?
evidence.
This isn't, let's make a deal here.
What a freaking weird. Did he just say if they'll agree to one, we'll agree to the other? Dude, that is so inappropriate. That just screams that the only way I get shit done is if I cheat, manipulate, bully, or coerce you into agreeing with me. Man, these guys are showing their colors so brilliantly during this trial.
Agrees that all the drone videos go back, we will agree that
It never got marked or moved in, even though it's been played.
Are you kidding me?
I am not kidding
Can
you.
we put it in evidence now?
That's what I think would be the proper way to do it.
If the defense agrees that all the drone videos go back, we will agree that should
Can
be
I
marked
run a
in
compromise?
evidence.
This isn't, let's make a deal.
Now you notice, I want you to notice the reaction of the defense attorney.
If the defense agrees that all the drone videos go back, we will agree that should be marked.
Yeah, they immediately went, are you kidding me? We're not going to agree to some shit in order to get something that's supposed to be in. We have to let something else that's not supposed to be in? Are you kidding me? They immediately knew that was an absurd suggestion. And the judge had the same response.
Run a compromise. This isn't, let's make a deal here.
I mean, this is just outrageous. These DAs literally think nothing applies to them. They are so used in standard operating procedure of bullying and lying and manipulating to get their way. I'm telling you, man, these guys are freaking horrible.
They did not mark the evidence. They did not move it.
But it was played to the jury.
Yes, and not marked or moved.
I thought it was part of the hard drive because everything was going in.
And I thought we gave them a full and complete copy of the video. So
Well, I'm going to reopen the evidence and admit what they saw. Give it the next sequential number. Well, how can I not give it to them? You tell me.
Then I would ask that evidence that's been admitted also go to the jury, that has been legally admitted in front of the jury, and follow the proper procedure.
Let's take one thing at a time.
Your Honor, just for the record as well, there's an additional difference that we found in the metadata between the two videos, is that if you look at the metadata from the file that we received from the state, is their create date is 11/5/2021 at 15:10:31. If you look at our video that we were provided, the metadata, the create time is 21 minutes and 19 seconds later.
Judge, we're looking at the Tucker Carlson interview with Attorney Pierce. It is not black and white, it is color, and it actually does seem to be high definition, like this video. We're watching, it's online, you can watch it.
Why have it black and white?
Mr. Rittenhouse's attorney has seen the real version.
What about that? If his prior attorney, he's got it.
Look at this little freaking weasel. Are you kidding me? Look, I'm right. Right here, Judge. I'm right. See? I'm the good guy. Are you freaking kidding me? You guys are freaking... Oh, my God.
I don't know. They said that Tucker Carlson bought it. And that's what goes to this whole thing, this Urban Air. We sent out an investigator to interview the owner of Urban Air to try and get this video. And I can get the report, I don't have it with me. And the individual lives out in the Lake Geneva area. And he lied to our investigators and said we were mistaken, that the drone permit wasn't for this video. And now it's come from his company. He shut down his company 17 days after this video was released. We've tried to get this video. And then it shows up on the Friday after the trial has started. And it's dropped off by his employee, not the person who we interviewed who owned the company.
That sounds pretty freaking shady to me.
I don't know who was interviewed. I believe that... Is the owner Mr. Beeman? Oh. Okay.
I'm Jamie. I know I answered no Mr. question. I apologize.
Well, this is number 5, and they say, please prepare. And then it lists these things, and then it says, we will request when ready, and they haven't followed up. So I'm playing short. Maybe the ball won't come to me.
So,
Oh my God. So now he's like, if I don't have to make a decision on it, I won't. So only if the jury forces me to make a decision on it, I will. Is that I guess in some way that's a safe move. If he makes a decision and they don't ever call, they can still challenge his decision. But if they don't ever call, his decision wouldn't matter. I don't know why he doesn't make a decision. Again, I don't know why judges are so reluctant to go against the prosecution. It's just almost like it's pulling teeth. And when I was working for the prosecution, I thought it was great. I was like, shit, we always win. We always get that. Yeah. But in the defense, I thought sometimes got too much because they would fight these little things and win. And I'd be like, really? He gave them that? But looking back, defense always got the little shit and the DA got the big shit.
well, if we're moving on, at least for the moment. Let's go to number 4.
Yeah.
So it seems that the request, it says view video, but I believe it's actually, 3 videos.
I did not hear you, sir.
It asks for a video, but I believe they're actually asking for 3 videos, and I think we agree on this, that it asks view video starting with Mr. Grosskreuz's interview with Mr. Rittenhouse. That is Exhibit 3. It's also duplicated as Exhibit 57. That is the live stream that Mr. Grosskreutz took that night.
I guess he doesn't wear a pin unless he's in front of the jury. He's had a pin on every day of the trial. So it must be to impress or influence the jury. I would really want to find out what these things mean. He might be sending some subliminal message to the jury that we don't know about. Freaking little weasel.
That does not actually depict the second incident. It does, you can hear the shots, but then it asks to 10 seconds after Mr. Grosskreutz shooting. I believe that's what's referred to as the BG on the scene video, which is number 5. And then it indicates in regular and slow motion. The only slow motion of that incident is the BG on the scene video, and that was the one that Dr. Black created and played. That was moved and admitted. It does not formally have a number because it's on a drive. We do not object to it being given a number and sent back, played however the court deems appropriate. So we would ask that. So I believe there's 3 exhibits they're requesting. The state does not object to them having access. However, it is deemed appropriate to those exhibits.
All right. So, that's by agreement. And then the question is where and what restrictions will be put on their use of those videos.
The state's position is that They should be given the exhibits or told what numbers they are. The courtroom should be cleared. They should watch them on the monitors they've been watching the whole case on. And that can be set up, and then everyone can leave, and they can discuss it. Now, it says...
All by themselves, or
By themselves.
okay?
Just as they
I
are in the
assume
jury
that
room.
somebody has got the technical ability to trigger playing of the videos.
That's a fairly simple process. They can be given a computer with you just plug it into the side, and then they can just press the thing. If there's...
Computer, it doesn't have other matter on it.
We have, I believe our computer, if it doesn't have anything else in this case, it may have like Microsoft Word or something on it, but there's no other evidence.
I wouldn't trust a DA to give them a damn computer. They'll hit a thing and it'll pop up some bullshit that they'll be like, oh, we didn't know, sorry. There's no way I would let the DA provide a computer to this jury without going over it first myself and trying to get something else to come up.
Of this case on it.
See, the problem is when they got nobody in there because jury deliberations are private. So they would have to clear the courtroom. They can't even have somebody work the computer for the jury because then he would be involved in the deliberations. That's why I said the fact that some marshal is saying he heard something just doesn't pass the smell test to me.
It's not my computer. It would be we have some standalone laptops to do this type of thing.
What's the defense position?
We were talking about it, and
Put the shit on a thumb drive. If you got a smart TV, plug the thumb drive into smart TV. The only thing on the thumb drive should be those three things, period. Now, there's no chance of something arbitrarily, accidentally on purpose by the DA that pops up.
The question that I have, and I don't have an answer because it wasn't in any of these cases, is there any right, if we're doing it in court, is there any right for Mr. Rittenhouse to be present?
Any more than if they had paper exhibits and they were discussing them. And certainly the defendant can't be in the room when they're talking about them.
Well, I agree
Why
with
is
that.
the video different?
Well, if you clear the room and say this is now the jury deliberation room, which is what they've asked.
No. I want to go back a step.
Okay.
Supposing I said, well, let's just get a computer that has nothing else on it, or that is everybody
Bingo.
feels it's sufficiently sanitary, and let's put these exhibits on a flash drive or download them onto the computer, whatever, and then send that upstairs. Let them do it just like they would if they were paper exhibits, and they can play it and discuss it as much as they want. Now, I'm talking right now only about question number 4, because there's other issues with respect to question number 5, and fortunately they're not here yet because they haven't requested it. But this would be a departure from the Anderson case for sure. That would not be incompatible with what I did in the Flint case. Flint. Who's okay with that?
I'm sorry.
Who's okay with that?
We are okay with that.
Based on what you said, so we're not waiving anything on 5,
You're not waiving anything on 5.
then that's okay for 4.
Okay, now we just need to get a clean computer. And you say you have some available, Mr. Krause?
Yeah, I would believe freaking the DA. Of course I would.
One of those?
I have to look at it, but if you think
Look at it. Well, I'm going to go and do something else. I'm not going to go. I'm going to stay. I'm going to stay and do something else. And I'll let you fellas try to work this up. And
At this point, Your Honor, they have not requested what we're fighting about.
they have not requested.
At this point, they have not requested what we're fighting about.
You are correct.
Okay.
All right. So there we are. We'll see how this turns out. I still didn't hear anything on the mistrial, or he hasn't ruled on that. And you notice the topic of someone overheard the jurors, and there's 2 that are held out. Notice that never came up. We call that a clue. All right. Well, then out there. See you on the next one.